To this now, accused number 4 in the Senzo Meyiwa Murder Trial, Mthokoziseni Maphisa, once charges against him dropped. Defense counsel Zithulele Nxumalo says the state only called one witness who claims to have seen all 5 accused at a hostel the same evening Meyiwa was murdered. Now, Nxumalo says, however, no one else was called to corroborate these allegations. Nxumalo also says the evidence of witness Constable Sizwe Zungu should be approached with caution. Maphisa is the only one applying for a discharge after 4 of his co-accused abandoned the process. For more on this discharge application, we're joined by Legal Analyst Kabelo Seabi. Kabelo, good evening to you and thank you so much for your time. So let's firstly just start with an understanding of what exactly it means when one is asking for a discharge.
Good evening. In a criminal trial, one must remember that it is the prosecution that begins to lead evidence, and it is the prosecution that carries the burden of proving the guilt of the accused. Now, the prosecution in this matter and in criminal cases, once it has adduced all the evidence it intends to adduce in a trial, and it closes its case, at that stage, the question arises as to whether the evidence that the state has or the prosecution has put before the court, whether there is a possibility that the accused may be found guilty. And I use the word may be found guilty. So that is what a Section 174 actually entails. It is an examination of the case that has been placed before the court by the prosecution, and a determination must be made as to whether, on the strength of that evidence, is there a possibility that the accused may be found guilty.
So listening to you then, is it correct to say this doesn't mean that the accused is found not guilty in the same way as after a full trial, but it's in this particular matter saying possibly there's no legal basis to continue?
Yes, in a 174, the determination is merely as to whether is there a possibility of a conviction arising from the evidence or not. So the court does not actually evaluate and analyze the evidence on the same test as at the end of a trial. At the end of the trial, the test is whether the prosecution has proven the guilt of the accused beyond reasonable doubt. So at this stage, it's merely a test to determine whether there is a possibility of a conviction.
Yeah, and
there are 2 different tests.
Yeah, and when you look at this then, right, his lawyers, for example, argue in part that for them the state has actually failed to prove that he was a part of a plan to assassinate Meyiwa, and that there is nothing in the bank records as well that would suggest that he received any proceeds from the alleged mastermind for the killing of Senzo Meyiwa. So for you, when you look at the case that has been brought forward by his lawyers, is it strong enough?
You have to take in cognizance that in a criminal trial, the prosecution is entitled to rely on what we would call circumstantial evidence. There isn't any direct evidence that implicates accused number 4, but one must then go and look at the circumstantial evidence from the various witnesses as to whether that evidence does it point to any participation by that accused person. And in this regard, as I said, all that the court has to look at is whether can a circumstantial case exist on which the accused can possibly be found guilty. And if it exists, that application for discharge would not succeed.
Can it be appealed?
A Section 174 is not appealable. You cannot appeal a refusal of that application.
And when you then look at, for example, what has been put forward, right, and given what you are saying then, how much of a tall order is this? for his lawyers, given the fact that you do have the other accused that have also decided not to continue with this application?
The further aspect, I think, that I have not yet touched on is that in this Section 174 application, where you have multiple accused, and there is also the possibility that another accused may come forward and the evidence of that accused person may strengthen or support the state's case, that also is a consideration that the court will pay as to whether to grant a discharge at this stage or not. The case that has been made out, one must remember that it is circumstantial in the sense that it would want to suggest that case that accused number 4 associated with the other accused. They were at the same place, near the place where the offense occurred, and also that there are other aspects that seem to suggest that accused number 4 had acted together with the same objective as the other 4 accused persons. That is exactly the nub of the issue as to whether the court finds that that circumstantial evidence, is it sufficient to be used to convict accused number 4, whether that possibility of a conviction arising from that evidence exists or not.
It's interesting because if one is to listen to what you're saying, then it does complicate the case for him and doesn't make it as easy as just asking for a discharge. The fact that there are other accused in this matter, and now that they would have also abandoned the Section 174 bids.
Obviously, at this stage, the prosecution is entitled to rely on the evidence of a co-accused against the accused person. This would be the evidence when that accused person goes into the witness box to testify, not the evidence in a confession. The evidence when that accused testifies. The prosecution may use that evidence. Now, because the other 4 accused, as matters stand, if they are not asking for discharge, the possibility is that they are going to testify. Therefore, the court will bear in mind that arising from those 4 others' evidence, there might be a possibility that they may come with evidence which supports the prosecution's case.
Wow, quite an interesting one. Thank you so much for speaking to us. Let's see then how the state actually responds to it. And I'm keen to hear your thoughts, just following that. Thank you so much for talking to us. That was legal analyst Kabelo Seabi speaking to us on the developments there in the Senzo Meyiwa trial there.